This is Barry Zalma speaking for Claim School Incorporated concerning why criminal lawyers should be disbarred. In the state of New York, a lawyer convicted of insurance fraud was only suspended for 2 years from the practice of law. Insurance fraud is considered universally as a crime of moral turpitude. Regardless, the New York State Bar was only asked to join with the New Jersey State Bar, who suspended a lawyer after he was convicted of insurance fraud and other wrongful conduct for 2 years, rather than considering disbarring the lawyer. In the matter of Neal Meridith Pomper, an attorney and counselor at law, the New York Supreme Court Second Department concluded that Pomper was admitted to the bar at a term of the Appellate Division of the Supreme Court in the Second Judicial Department on May 6, 1981. The court directed Pomper to show cause why an order should not be made imposing discipline upon him for the misconduct underlying the discipline imposed by an order of the Supreme Court of New Jersey. The Supreme Court of New Jersey, filed on October 21, 2020, ordered that Pomper was suspended from the practice of law in New Jersey for a period of 2 years, retroactive to September 18, 2019, the date of his temporary suspension. Pomper and the New York Office of the Attorney Ethics executed a stipulation providing in relevant part as follows, quote, "The respondent was admitted to the practice of law in the state of New Jersey under the name Neal M. Pomper in 1982. The respondent's disciplinary history in New Jersey consists of a private reprimand in 1986, an admonition in 2004, a censure in 2009 for assisting his paralegal in the unauthorized practice of law. On September 18, 2019, the respondent was temporarily suspended from the practice of law based on the misconduct underlying this matter in Re Pomper, set forth below. The respondent stipulated to violating New Jersey rules of professional conduct and New Jersey rules of court, and the rule that a criminal act that reflects adversely on a lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects, and conduct involving dishonesty, fraud, deceit, or misrepresentation. The basis for the respondent's violations stem from his conviction of inter alia insurance fraud and his poor record-keeping practices and commingling of funds. The insurance fraud for which he was convicted involved the fact that after his home was damaged in a flood in 2011, he contracted with Rivera Remodeling to remediate the water damage. At the time, the respondent had a homeowner's insurance policy with a Selective insurance company. The respondent's employee, Larissa Sufaru, sent Rivera's purported invoice for the remediation to Selective. Sufaru wrote paid in full on the invoice to reflect the respondent's alleged payment of $14,000. Selective investigated the claim, and upon learning that Rivera had not prepared the invoice, Selective denied the respondent's claim. On July 10, 2015, a superseding indictment issued by a grand jury in Middlesex County charged the respondent with the following crimes: 1. Third-degree conspiracy to commit insurance fraud. 2. Third-degree insurance fraud. 3. Third-degree attempted theft by deception. 4 fourth-degree uttering, and 5 fourth-degree forgery. Pomper was found guilty on 3 of those charges. Third-degree conspiracy to commit insurance fraud based on his agreement with Sufaru to create and transmit a fraudulent invoice to Selective to receive insurance funds. 2, third-degree insurance fraud based upon the respondent having directed Sufaru to create a phony invoice for the purpose of obtaining a benefit from Selective. And 3, third-degree attempted theft by deception based upon the theory that if Selective had relied on the phony invoice, the respondent would have received funds from Selective that he was not entitled to receive. The respondent was found guilty on those 3 charges, but not found guilty on the forgery charge. Pomper was eventually sentenced to 3 consecutive concurrent 1-year terms of probation with mandatory fines and avoided jail. On or about August 28, 2018, the OAE audited the respondent's financial records for the preceding 12-month period, which revealed the following deficiency. Client ledger cards were not fully descriptive. Legal fees were not deposited into the attorney business account, hereinafter his business account. Improper business account designation, improper attorney trust account designations, non-compliant business account and trust account image process checks, and improper electronic transfers from the trust account. The audit also revealed that on December 28, 2017, Pomper had deposited into his trust account a $5,675 check for legal fees from a client, Thomas Paddock. On January 5, 2018, the respondent transferred those funds into his business account. Pomper stipulated that he commingled personal and client funds when he deposited the Paddock check into his trust account. He also stipulated to engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation by placing the Paddock check into his trust account in an attempt to reduce his tax liability for 2017 and receive the benefit of a presumably more favorable tax bracket in 2018. Pomper also stipulated that he had been the subject of random audits by OAE in 1987 and 2013, and he had certified to OAE on April 10, 2013, that he corrected the 2013 deficiencies. The Supreme Court of New Jersey's order to show cause found that the grievance committee for the 9th Judicial District informed the court about Pomper's discipline in New Jersey. The respondent did not notify the grievance committee and the court of his temporary suspension in 2019 or of the discipline imposed in the New Jersey action in 2020. To date, the respondent has not responded to the court's order to show cause, has not asserted any defenses, and has not requested additional time with which to respond. Based on the foregoing, the court found that the imposition of reciprocal discipline was warranted based on discipline imposed by the Supreme Court of New Jersey. In view of the circumstances of the case, the court concluded that the appropriate sanction is a suspension for a period of 2 years. The New York State Bar, in my opinion, was kind to Mr. Pomper, who admitted to conviction of a crime of moral turpitude and to actions of moral turpitude by misusing clients' funds, and still he was not disbarred. Although the state may have felt sorry for him since he stipulated to his wrongdoing, a lawyer should not be allowed to practice law after being convicted of insurance fraud, including a false document in support of a false insurance claim. This video was adapted from my blog, Zelma on Insurance. Thank you for your attention.